Judge, to the best of my knowledge, he has no failures to appear, never having fled the jurisdiction of the court, and he's lived the majority of his life here in Brevard County, and we're going to be asking for a reasonable bond on count one. There are two bonds as to count two, and count three, $15,000 and $500. We're asking for a $25,000 bond.
On count one, the premeditated murder?
Yes, Your Honor. He's still innocent until proven guilty.
Okay.
It doesn't usurp his rights of, again, asserting his right to innocence until proven guilty.
All right. Well, Mr. Skinner, just for the record, it looks like there was an indictment that was filed on June 26th. Count one was for first-degree premeditated murder. Count two is for burglary of a dwelling, and count three was for petty theft. The bonds that were placed on it was none for the first-degree premeditated murder, $15,000 for the burglary of a dwelling, and $500 for petty theft. Let me hear from the state on this matter.
Well, the notion that there was no information that was filed, there was papers that were originally filed when he was charged with second-degree murder. Ultimately, he has been indicted for first-degree murder, and the state believes that he poses a great threat to the community, and as a result, no bond is appropriate.
Okay.
Judge, we're not talking about a charging document, the information. We said there's no sufficient probable cause for this court to look at. This court cannot find probable cause for what the documents that you have before you right now. And as a result of a no 923 or any other police report or the court's ability to find probable cause in this case, that I'm asking the court to find no probable cause merely because there's a grand jury indictment does not ipso facto mean that the court adopts it and therefore there's probable cause. It's this court's obligation to mandatorily find probable cause, and you can't find it in a vacuum. There's nothing before this court to find probable cause based upon any documentation whatsoever. In that event, then the court, in the alternative, has an obligation then to grant a bond as to count one. We'll accept the bonds as to count two and count three. We're not arguing that. Nor the probable cause on the burglary of a dwelling or petty theft, just so that we don't have to litigate the bonds on count two and three.
Now, I'm assuming that there is an affidavit.
Well, we object to any other assumption that the court makes, Your Honor, as to any probable cause finding by anybody else. The court is not allowed to simply, with all due respect, and I'm not suggesting this court ever does this, but the court is not allowed to rubber stamp what other judges do. You have to look at the facts and the evidence to determine probable cause. It's a first appearance, and every individual who comes before this court on a first appearance has the right to have his case looked at to determine probable cause and the factors therein, whether or not he's employed, whether or not he's ever fled the jurisdiction of the court, whether he's ever failed to appear, prior criminal history, length of ties to the community. I'm ready to go into all those factors, Judge.
All right. Well, in looking at
Lack of assets. I'm sorry.
That's okay. In looking at Mr. Skinner's case, I'm looking at the affidavit for arrest warrant because that's where the facts are set forth. That would tell me, what the circumstances were around the incident at issue. And it's my understanding, just looking back at everything, that there was an arrest warrant issued at one point in time. There was subsequently a grand jury indictment. In reviewing the affidavit in support for the arrest warrant, there certainly is, in my opinion, probable cause for all three charges. So is it your position that I'm not permitted to look at that arrest affidavit?
No, Judge, I have no arrest affidavit here. As to the packet that I'm given, and I believe the court did not have a physical document of a 923-01. If you're now looking it up for purposes of the record on your computer and you've read the 923-01, I would only articulate to the court that the only evidence that I know of that leans towards charging my client is the fact or the alleged fact that he had shoes on that had the blood of the alleged victim on him. And that there's a reasonable hypothetical answer to why he had blood on his shoes if in fact they are the blood of the victim, because he's in and around the crime scene. It's that simple. So with all due respect, I don't believe there's any other evidence that he was the one who caused and or contributed to the death of the alleged victim in this case.
All right, Mr. Lockard.
The initial affidavit indicates clearly what his participation was in this murder. There has been testimony provided for the indictment. As a result of that, the court can take that into account, that the information provided by the indictment, including the testimony of the medical examiner and the other officers that were involved, rise to the level of reasonable.
This court did not receive that testimony. This court did not hear that testimony. And the mere fact that the state articulates that there was some testimony from somebody in and of itself is not substantial. It's not relevant. It's not material, because this court has not heard it. Now, if the court's going to judge merely by the 923-01, then I understand that. But based upon the 923-01, I think it's scant. I think it's ineffective in ascertaining that my client is the only suspect that could be charged. There are 2 or 3 other individuals that were out there at the time in and around the area with guns. My client didn't have a gun. He didn't have a weapon. There's no fingerprints. There's no other DNA that I know of at this time, Judge, that would assert that my client was the one who caused and or contributed to the death of the alleged victim.
You know, this situation is a little different simply because, you know, once the arrest warrant was executed and served, this case did go to a grand jury, and there was a capias issued setting the bonds. You know, they did have the opportunity, and I understand what you're saying, but, you know, I can't look at this situation in a vacuum at this point. I am, and of course you can take it up with the judge that is assigned to this particular case. But at this point in time, I am going to find that there is probable cause for each of the charges, and I'm going to keep the bond amounts the same. So in count 1, it's a no bond. Count 2, $15,000. Count 3, $500. Next court date on this is August 6th at 8:30 for docket sounding in front of Judge Maloney. I'll just add that based upon the information that I have had to review, it does appear that Mr. Skinner does pose a great threat to the community, and thereby supporting the no bond on count 1. So any issues to be addressed with respect to my findings can of course be addressed to Judge Maloney.
Yes, Your Honor. Thank you. Have a good day.
Okay. All right. Thank you.
Okay.
All right. Next we have Torrance Hawkins. All right, good afternoon, Mr. Hawkins.
Good afternoon.
All right, sir, you're charged with arson in the first degree and attempted first degree felony murder. They're both first degree felonies. I'm going to appoint the public defender's office to represent you in your case. I do find probable cause for each of the charges after having reviewed the arrest affidavit. Let me look to the state for a bond recommendation.
$50,000 for each count, Your Honor.
All right, Mr. Kennedy.
I'm sorry, I didn't hear what the state's recommendation
$50,000 for each count.
was. Judge, I'm sure that Mr. Hawkins would be unable to pay a bond of that amount. I'd ask for the court to consider a bond of no more than $25,000 per count.
They told me I was coming to jail for domestic, and I didn't.
Don't say anything about this case.
Yeah, sir, the charges that are pending are the arson charge and the attempted first degree felony murder.
Okay.
All right.
It's all good.
All right, sir, after having reviewed the arrest affidavit and looking at the PTR sheet, I'm going to go ahead and set bond on count 1 at $50,000 and count 2 $50,000. You can address any issues with respect to the bond that I've set directly with your case judge, Judge Reinman. But in the meantime, your next court date is going to be July 31st at 8 o'clock for your arraignment in front of Judge Silverman. As a condition of your release, if you're able to post bond, you're not to return to the location of the offense, and you're not to have any contact with the alleged victim in the case. Did you reside with the alleged victim?
Yeah, that's me and her house.
Okay. I'll authorize a one-time return with law enforcement so that you can gather personal belongings, but if the only way that you're going to be able to return to the residence outside of the one-time return with law enforcement is if you get the conditions modified in front of your case judge, okay? All right. So I think that takes care of everything. Thank you. All right, next we have Stephen Anderson. All right, Mr. Anderson, you're here on a fugitive warrant. It's from the state of Texas. There is no bond on the warrant, so you will be held until you are picked up. And this is the extradition paperwork.
Okay.
Okay. All right, so Mr. Anderson, have you signed the waiver of extradition paperwork?
No, not yet.
All right, so you signed it. So we're going to set it for a 10-day control. Is that right? Okay. All right, so Mr. Anderson, now that we have the waiver paperwork, we're going to set a 10-day control date, July 12th at 1:15 here at the jail to determine if you've been picked up. Okay. All right, thank you very much. All right, next we have William Birch.
My bad.
How you doing, y'all?
Good, how are you?
Pretty good.
All right, Mr. Birch, you're also here on a fugitive warrant. It's from the state of Pennsylvania. There's no bond associated with the warrant, so you will be held. Do you have waiver of extradition paperwork in front of you?
I guess so.
Okay. Have you had a chance to look at it?
Nah.
All right. Well, here's the situation. If you waive extradition, then there'll be an order for them to pick you up within 30 days.
Yeah.
And what we'll do is set a control date for 10 days out to see if they have picked you up. If they fail to pick you up within the 30 days, you can petition the court for release or for bond to be set. If you don't sign the waiver paperwork and you choose to fight extradition, you'll be held for 30 days, and that can be extended up to an additional 60 days depending upon the situation. So
Yeah.
it's up to you, but if
No.
you...
I don't have a problem with going back. I was they think this is my case here. They think it was a new case, but my case is from 2016. I had just came down. I had a round trip flight to go back on the 27th. I had court on April 30th. It's like right now, I mean, I went to court yesterday. I got probation. I'm trying to get to the airport so I can get home, but they, you know.
Okay. Well, unfortunately, we can't do anything about the
Yeah.
issues from Texas or from Pennsylvania, but if you do sign the waiver paperwork, then they'll have the ability to pick you up and you can try to get it straightened out.
I can barely see. I don't know what he was. Yeah, but I don't have a problem with going back there. It ain't about nothing.
Okay, so you're going to go ahead and sign it then?
Yes, ma'am.
All right, so then what we'll do is set the status hearing for July 12th at 1:15 here at the jail.
All right,
You'll
thank
just
you.
need to make sure to sign it and
Yeah.
they'll bring it in.
All right, thank you. Where at?
All right, next we have Juan Casiano.
Yes, ma'am.
Okay. All right, Mr. Casiano, you're here on a fugitive warrant from the state of New York. It appears that you have already signed a waiver of extradition. So a court date will be set for you July 12th at 1:15 here at the jail to see if you've been picked up.
Okay.
All right, thank you.
Thank you.
right, Mr. Graham?
Yes, ma'am.
All right.
Order to transport, Judge.
All right. Okay, so Mr. Graham, you are here on an order to transport. There's no bond. You'll be held until your court date, which is July 5th, in front of Judge Lemonitis for sentencing. Okay.
Understandable.
All right, thank you. Tabitha Cook Swanson. All right, did she, all right, ma'am, you are here on 2 cases. I'm appointing the Public Defender's Office to represent you in each case. The first case, you're charged with uttering forged bills, checks, drafts, or notes. Second charge is fraudulent use or possession of personal ID without consent. And the third is unlawful possession of personal identification. I have reviewed the arrest affidavit in this particular case, and I do find there's probable cause. What's the state's recommendation for bond?
$3,000 for the felonies and $500 for the misdemeanor.
Okay.
Is there any way, am I allowed to speak or?
Well, hold on just a moment. Let me find out from your attorney what he's recommending for bond as well.
Judge, I have no objection to the schedule. Unfortunately, she lives out of the county.
Okay, all right. All right, so Ms. Cook Swanson, I am going to go ahead and set your bond at the scheduled amounts for count 1, 3,000, count 2, 3,000, count 3, 500. With respect to this particular case, and just for the record, it's 2018 CF 34009. As a condition of your release, you are not to have any contact with the victim in the case, and you're not to return to the location of the offense.
I mean, is there any, again, I have no access to any way to bond out.
Okay. Well, you do have an attorney, and so what you can do is make contact with the attorney that's going to be assigned to you to see if you can address your bond issues with Judge Maloney. She's going to be your judge in both of these cases. So if your attorney feels it's appropriate to file a motion to modify the bond, then that decision can be made. Okay. But for the time being, this is where I'm setting bond at. We've done it for the first case. Your court date's going to be for an arraignment July 31st at 8 o'clock in front of Judge Silverman. Your next case, which is 2018 CF 34010, the charges are uttering forged bills, checks, drafts, or notes. Count 2 is fraudulent use or possession of personal ID information without consent. Count 3, unlawful possession of personal identification, and another count of unlawful possession of personal identification. And I did review the affidavit in this case as well, and there were 2 forms of ID that are alleged to have been in your possession. And it was a separate incident from the one that we just addressed in the first case. I do find that there's probable cause for each of these charges. And I'm assuming that there's not going to be an objection to the bond scheduled amounts for this case either.
That's correct.
So count 1, 3,000, count 2, 3,000, count 3, 500, count 4, 500. Same conditions apply, no contact with the victim in the case, and no return to the location of the offense. Next court date, July 31st, for your arraignment. Okay.
Am I done?
All right.
Everybody's-
Jennifer Marsh. All right. Good afternoon, ma'am.
Afternoon.
Should we apply? All right. So I'm appointing the Public Defender's Office to represent you in your case. You're charged with battery and petty theft. I've reviewed the arrest affidavit and do find probable cause. Recommendation for bond from the state.
$500 for each count.
Mr. Kennedy?
Judge, considering her record, how does the court consider a scheduled bond for count 1 and ROR count 2?
All right, let me take a quick look.
I don't have an objection to that.
You don't have an objection to that? Okay. And I am looking at the PTR sheet, and there's,
I request a different attorney. I'd like to
Next.
hire my own counsel, if that's possible.
You have the ability to hire your own attorney at any point in time. Once you do that, then there'll be a substitution or,
There's explanation from my previous record that he's not privy to.
okay, well,
I had to plead guilty to that misdemeanor. I had no choice.
okay, all right. I think what's being communicated at this point is that you have very little history, which is why there's no objection to
Okay.
you being ROR'd on one of the
Okay.
counts, so.
I don't understand all the terminology.
Okay.
I'm not an attorney.
I understand. So what we're going to do at this point is set your bond on count 1 at $500, count 2 ROR, okay?
Okay.
As a condition of your release, you are not to have any contact with the alleged victim,
Absolutely.
and there'd be no reason for you to have contact correctly. There was no, you didn't reside together or anything like that. Okay. All right,
didn't
so
spit
just
on
no
me.
return to the location of the offense as well. Your next court date's going to be July 16th, 9 o'clock in front of Judge Ingram in Melbourne. Okay.
All right. Fantastic.
Okay.
Thank you so much.
All right. Wendy Wilbert.
Your Honor, Ms. Wilbert intends to either hire counsel or represent herself.
Okay. All right, Ms. Wilbert. Okay, ma'am, you're here on an arrest warrant for violation of probation. Judge Dugan is your judge in this case and signed a no bond warrant. You said that you're going to be hiring your own attorney, is that correct? Or representing yourself? No? Okay. Do you want to have an attorney appointed to represent you?
Yeah.
All right, you didn't fill out an application? All right, well, what you're going to need to do in order to have an attorney appointed to represent you is to fill out an application. So if you want to,
Judge, she wadded it up and threw it away.
did she?
Yes, ma'am.
All right, well, you'll be given an opportunity to apply for an attorney, for the appointment of an attorney at any stage of your case, but you've apparently indicated that you didn't want to apply today, so.
No, I messed up on filling it out. So the way you just took it and didn't say nothing.
All right, well, you're in on a no bond warrant.
Uh,
Next court date is August 3rd at 9:15 in front of Judge Dugan. If you want to apply, fill out the application when you're more able to do so, then you can do that, and you may get called back in for a counsel review, but I don't think that you're able to fill out the application at this point. Daniel McQuillan. All right, sir, I'm appointing the Public Defender's Office to represent you in your case. All right, I've reviewed the arrest affidavit. I'm sorry, can you hear me?
Yes.
Okay, I reviewed the arrest affidavit prior to the proceedings beginning today. I did find probable cause for each of the charges here. It's aggravated assault, domestic violence, and battery domestic violence. What's the state's bond recommendation?
Nobody ever hit anybody. I don't understand. She took off on my
Sir,
phone.
sir, you don't want to talk about the case.
$5,000 for count 1, $1,000 for count 2.
All right, Mr. Kennedy?
No objection, Judge.
Okay. All right, so Mr. McQuinlan, I'm setting bond, count 1, $5,000, count 2, $1,000. As a condition of your release, you're not to have any direct or indirect contact with the alleged victim. You're not to return to the residence except for a one-time return with law enforcement. And give me just one moment to check something. Okay. All right. Your next court date is August 14th at 8 o'clock in front of Judge Baker for your arraignment. Okay. Russell Pratt.
Good afternoon, ma'am.
Good afternoon.
Sirs.
All right, I'm appointing the Public Defender's Office to represent you in your case. You're charged with aggravated assault, domestic violence, and battery domestic violence. All right, I do find probable cause for each of the charges. Bond recommendations.
10,000 for count one, 1,000 for count two.
Mr. Kennedy?
Judge, I'd ask the court to consider a bond of no more than 5,000 for count one, 500 count two. Gentleman's got no FTAs and one prior misdemeanor.
All right. In light of the allegation in the arrest affidavit, I'm going to set bond on count one at $7,500, count two $1,000, not to have any direct or indirect contact with the alleged victim, not to return to the residence except a one-time return with law enforcement to gather personal belongings. You're not to have possession of firearms, ammunition, or weapons, okay? Your next court date is July 31st, 8 o'clock in front of Judge Koenig for your arraignment.
Okay, thank you.
All right, thank you. Ron Tabias Torbert.
Hey, how are you? Your Honor, Mr. Torbert intends to either hire counsel or represent himself.
Okay. All right, sir. You're charged with domestic violence, assault, burglary of an occupied structure, and criminal mischief. I don't think he. Yeah. Oh, he did fill one out? He did not. Okay. Okay. All right, I've reviewed the arrest affidavit, find probable cause for each of the charges. State bond recommendation.
As to count one, ROR is to count two, 15,000. As to count three, 500.
Okay. Mr. Kennedy?
Representing himself, Judge.
Oh, I'm sorry. Yes, you're right. Okay. You said an ROR on count one?
Yes.
All right. Okay, Mr. Torbert, I'm going to go ahead and set your bond on count one at, well, you're going to be ROR'd on count one, count two.
Yes, ma'am.
The bond schedule's 15,000.
This is just.
Yeah, all right. Count two, 15,000, and count three, 500. As a condition of your release, you're not to have direct or indirect contact with the alleged victim, not to return to the residence. Actually, did you, at the time of this incident, were you still living with the alleged victim?
Yes, ma'am.
You still have personal belongings there?
Yes, I do.
Okay. You'll be authorized a one-time return with law enforcement, but it needs to be set up through law enforcement, not through other third parties. Okay.
Yes, ma'am.
All right. In addition, you're not to possess or consume illegal, it kind of goes without saying, but because of the allegations in the arrest affidavit, you're not to possess or consume illegal substances, okay?
Yes, ma'am.
All right. Your next court date, July 31st, Judge Silverman for your arraignment.
No, I do have a bond, right?
It's a total of $15,500.
So what's the, what I have to pay?
If you can get a surety bond, it's usually a percentage of each bond amount. Okay.
Thank you.
All right, Eugene Williams. All right, Mr. Williams, I am appointing the Public Defender's Office to represent you. You are charged with tampering or fabricating with physical evidence, use or possession of drug paraphernalia, loitering or prowling, and resisting arrest without violence. All right. I do find probable cause for each of these charges. Mr. Loughran?
Count 1, 2,500 for count, each for count 2, 3, and 4.
All right. Any objection?
No, ma'am.
Okay. All right, Mr. Williams, your bond for count 1 is $2,000, count 2, 500, count 3, 500, count 4, 500. Goes without saying, but as a condition of your release, no possession or consumption of illegal substances or paraphernalia, and no return to the location of the offense. Okay. All right. Next court date 7/31, 8 o'clock in front of Judge Silverman and Vieira. Caroline Johnson.
Your Honor, if Ms. Johnson would qualify, it's conflict.
Okay. Okay. All right, so Ms. Johnson, I'm going to appoint conflict counsel to represent you in your case.
Okay.
All right, you're charged with battery on a person 65 years or older.
No.
Oh, I'm sorry, that's the wrong. Give me 2 seconds. Okay. All right, so you actually have 2 cases. First one, it looks like you failed to appear for a plea.
I was arrested in the state of Texas.
Okay. Well, just give me a second. The information I'm looking at right now indicates that you failed to appear for a plea in front of Judge Maloney. The bench warrant was issued back on April 26th. And it's a no bond hold for judge, so you will be held on that until you can get back before Judge Maloney. You're scheduled to go in front of her for docket sounding August 6th at 8:30. In your next case, 2018 CF 33747, you're charged with use or possession of drug paraphernalia, 3 counts, and possession of a controlled substance. Is this continued from yesterday by chance?
Yes.
Yes.
Okay. Yep. All right. Okay. All right. I find probable cause. What's the state's recommendation?
500 for each count number 1, 2, and 3, 2,000 for count 4.
Okay. And this is conflict counsel, or am I? Okay. All right, Ms. Johnson, I'm going to set your bond on count 1, 500, count 2, 500, count 3, 500, count 4, 2,000. not to possess or consume illegal substances or paraphernalia. Okay. Next court date is 7/31, Silverman. Gordon Brown. All right, Mr. Brown, appointing the Public Defender's Office to represent you. You're here on a bench warrant for failing to appear for a VOP arraignment in front of Judge Ingram. She set bond at $2,000. We're going to go ahead and set aside and release the prior bond. Your next court date is July 26th at 9 o'clock in front of Judge Ingram in Melbourne. Okay.
Yes, ma'am. Thank you.
John Devers. All right, Mr. Devers, I'm appointing the Public Defender's Office. You're charged with battery on a person 65 years or older. All right, I find probable cause. Mr. Loughran.
5,000.
Mr. Kennedy.
Judge, I just looked up, we need the conflict off of Mr. Devers' case.
Off of Mr. Devers' case? Okay. All right, so Mr. Devers, I'm going to appoint conflict counsel. All right. After having reviewed the allegations in the arrest affidavit, I do think that the $5,000 bond is appropriate, so I'm going to go ahead and set bond at $5,000. You're not to have any contact, direct or indirect, with the alleged victim, and you're not to return to the residence unless you need a one-time return with law enforcement to gather personal belongings. Okay. Next court date is going to be July 31st at 8 o'clock in front of Judge Silverman for your arraignment. Okay.
That's it.
Let me talk for a second.
All right. Is this Bernard Michelani? Hurst? What happened? PTR? Okay, great, thank you. All right, Frederick Hurst?
This is a,
Please, okay.
you ready to go? Okay, the state's offer was, as I said earlier, an adjudication. You plead guilty to the charge of trespassing, which was in this police report. Right, and you plead guilty. It's 26 days, Brevard County Jail with 26 days, credit time served, court costs and cost of investigation, and the judge will give you a couple months to pay that. Okay? Any questions? Well, step back here and ask me. You would get out. I don't know. I don't have one here that you would be correct. So you probably have to go back on your own. Okay? Yeah, can you do that? Okay. Thank you, Judge.
Okay, no problem.
Right. Okay. He was just concerned, he wants to go to Circles of Care when he gets out.
Okay.
Judge, Mr. Hurst has agreed to a plea offer made by the state in case number 2018 MM 30510 in exchange for a plea of guilty to the charge of trespassing, first-degree misdemeanor. It'll be an adjudication of guilt, 26 days Brevard County Jail with 26 days credit time served, court costs and cost of investigation of $77.50 to Titusville Police Department. And we're going to ask the court for as much time as you will allow him to pay those costs.
Okay. All right. So, Mr. Hurst?
I have a question.
Okay.
Did I miss another one of these dates? I supposed to came to appearance at another time, I think.
Yeah, July 5th would be your next date. But this takes care of that.
Okay.
Okay?
Okay. Thank you.
I don't have to go to there.
Right, you won't have to go to that.
All right. So, Mr. Hurst, I'm going to ask you a few questions, okay, and to get everything taken care of for
I
you.
got a question.
Go ahead, listen to the judge now.
All right.
Hassie said,
And Mr. Kennedy, if you could, with the microphone, just put it a little closer to him so I can hear him. Great. Thank you. All right. So, Mr. Hurst, your attorney just announced the terms of an agreement with the state. Do you understand what the agreement is?
I love you. Yeah.
Yes? Okay. All right. And at this time, you wish to enter a plea of guilty to the charge of trespass. Is that correct?
Sis.
Okay.
See,
All right. Is anyone forcing you to enter this guilty plea today?
I don't know.
You're not being
No.
forced.
Mano.
No.
Mano.
He says no.
No? Okay. All right. All right. So you are entering this plea voluntarily of your own free will. Is that right?
See.
Okay. All right. All right. And can you understand everything that I'm saying?
See.
Yes.
Okay.
Speak in English.
Yes.
All right. Thank you. I know what C means, but I just want to make sure you understand me.
Yo.
All right. So just bear with me for a couple minutes, Mr. Hurst. I'm going to try to go through this as quickly as I can, okay?
See.
Do you understand that by entering a guilty plea, you're waiving the right to a trial?
Sis.
Okay, and you're waiving the right to require the state to prove its case against you beyond a reasonable doubt. You understand that?
See.
Okay. All right. Are you thinking clearly so you understand the consequences?
Sis.
Okay. All right. So you haven't taken any drugs, alcohol, or medications in the last 24 hours that would affect your ability to think today?
Yeah.
You took medication, but you're thinking clearly, though, right? Yeah.
Okay.
It's your
I had
regular
questions. I had questions about it, but I didn't go
Let
get
the judge
questions
finish.
about it.
Let the
I
judge
didn't.
finish,
I didn't
okay.
go out.
Okay. Well, let me just confirm. So you may have taken medications, but right now you're thinking clearly. Is that right?
See.
Okay. All right. Have you had enough time to talk to your attorney about this case?
Yeah.
Yes.
I asked. We did our questionnaire.
You did all that. Okay. And he was able to answer your questions?
We questioned and I answered your question. I just answered your question.
Okay. All right. Just need to advise you of something, and it may not apply to you, but if you're not a U.S. citizen, entering a plea could have immigration consequences such as deportation, or it could affect your resident status. You understand that?
See.
Okay. Do you have any questions or concerns about anything you've been advised of?
Any questions? I think you got it all.
I don't have no outside charges pending there.
Any pending charges? Is that what you're asking about?
I don't have no outside charges pending. No
Outside charges?
No, this would be
no
it.
more
This
pending
is it?
charges.
Okay. No, it looks like this would be it.
Yeah, and you'd have no more court dates on this case. Okay?
All right. All right. So, Mr. Kennedy, do you stipulate to a factual basis?
I do, Your Honor, based on the 923.
All right, thank you. All right, with that, court does find there's a factual basis for the plea of guilty to the charge of trespass as charged in count 1 in case number 2018 MM30510. At this time, Mr. Hurst, I'm accepting your plea to the charge. I'm finding your plea has been given freely and voluntarily with knowledge of the consequences after having received the advice of counsel. In exchange for your plea, the court's adjudicating you guilty. You're going to be sentenced to 26 days Brevard County Jail with credit for 26 days served, so there's no further jail time. You're going to be required to pay mandatory court costs associated with the charge, including a $50 cost of prosecution. There's also a $50 cost of defense and a cost of investigation for the Titusville Police Department in the amount of $77.50. I'm going to give you 12 months to make payment of the court costs to the clerk's office. If you fail to make payment within that period of time or to get set up on a payment plan, there'll be a hold on your driver's license. Okay?
Where's the immediate? Toilet? Immediate toilet I can.
You need to use the restroom?
It's immediate
Okay.
toilet.
Okay, we'll get that in just a
Yeah, hold on just a moment. One thing I want to clarify is I'm sure there may be a trespass in place, but is there also a no return as a part of this agreement?
The state was asking for that for a year.
Okay. All right. So I will state, Mr. Hirsch, you're not to return to the location of the offense, which is Blues Market, for a period of 12 months. Okay.
And they may not want you back there anyway.
That's mocking. I mock you. I mock you.
Okay.
I mock you. I mock you.
Okay. All right, sir. You have 30 days to appeal the legality of the sentence. If you choose to appeal for that purpose, you'll have a right to an attorney.
Okay. You're good. Thank you.
All right. Thank you.
Thank you, Judge.
Eminem.
Thank you, Mr.
Eminem.
Harper.
Eminem.
Okay. Processed out here. Just a few hours.
Do we have Ernest Paget? All right, sir, you have an out-of-county arrest warrant. It's from Orange County. There's no bond on it. We're going to set a status hearing for July 2nd at 1:15 here at the jail to see if you've been picked up.
Yes, ma'am.
Okay, thank you.
Thank you.
Rochelle Williams. All right, good afternoon, ma'am.
Hi.
All right, you have an out-of-county arrest warrant from St. Lucie County. There's no bond on it, so you will be held. We'll see if they have picked you up on July 2nd at 1:15.
Okay.
Okay.
Thanks.
All right, are you Ms. Cowell?
Yes, ma'am.
All right. Okay, I'm appointing the Public Defender's Office to represent you. You're here on a violation of probation. There was a warrant issued by Judge Maloney. The bond amount was $15,000. Your next court date will be in front of her, July 31st at 8:30.
Okay.
Okay? All right, Mr. Deese?
Yes, Your Honor.
All right. Okay, sir, you are here on two separate cases, on-site VOPs. I'm appointing the Public Defender's Office to represent you in both cases.
Yes, Your Honor. Can I ask your request, please?
Okay.
I have two jobs that I'm working 80 hours a week, 7 days a week. I can't afford to stay in here. Is there a way I can get a bond?
Well, I'm going to take a look at the arrest affidavit since these were on-sites, and we'll figure out what's appropriate, okay?
Yes, ma'am.
All right. We get the state's position on bond in this case.
5,000 for each case.
Judge, I'd ask for $2,500 per case.
All right, well, the issue with this is that it looks like there were VOP issues in the past, and we also have, looks like this last The last sentencing was at the end of March, and we already have another violation in each case. I'm going to set bond at $5,000 for each case. If you need to have that bond amount addressed further, you'll need to have a motion filed for Judge Reinman to hear. Okay, but aside from that, your next court date is going to be August 13th at 1:30 in front of her. If you are able to post bond in these cases, you need to report to probation within 48 hours. Okay?
Yes, Your Honor.
All right, thank you.
Thank you.
Richard Duty?
Correct.
All right, sir, I am appointing the Public Defender's Office to represent you. So you're charged with aggravated battery and battery domestic violence. It looks like this came in on an arrest warrant. All right, the aggravated battery, the bond was set at $15,000. The battery domestic violence is at none at this point. Let me take a look at the affidavit. So if I'm reading this correctly, it looks like there's one victim.
Yes, Your Honor. That's my understanding.
All right, what's the state's position on the battery DV?
5,000.
Mr. Kennedy?
Judge, first degree misdemeanor, I'd ask for a bond of no more than 1,000.
All right, sir, I'm setting the aggravated batteries are already at $15,000. I'm setting count two at the at $5,000 based on the specific allegations in the arrest affidavit and looking at some of the prior history here. So the total bond is $20,000. You're not to have any direct or indirect contact with the victim. In this case, you're not to return to the residence except a one-time return with law enforcement to be set up directly through law enforcement. That's if you need to gather personal belongings. You're not to possess firearms, ammunition, or other types of weapons during the pendency of this case.
I understand, Your Honor.
All right, your next court date is July 31st, 8 o'clock, Judge Silverman. Is Greg, oh, actually, what's your last name, sir?
Griggs.
Mr. Griggs, my apologies. All right, sir, I'm appointing the Public Defender's Office to represent you. Looks like you're here on a failure to appear bench warrant on an order to show cause. This was in front of Judge Silverman. He set bond at $250. Your next court date is July 17th in front of Judge Silverman. Okay. All right, thank you. All right, Mr. Lawson, I'm appointing the Public Defender's Office to represent you. You're here on an on-site VOP. All right. All right, Mr. Kennedy.
Yes, ma'am.
I'm sorry, Mr. Loughran.
The state is requesting $10,000, Your Honor.
All right, now, Mr. Kennedy.
No objection, Judge. I believe he's got holds out of Orange anyway.
All right. All right, Mr. Lawson, I'm setting your bond on this at $10,000. Your next court date is August 3rd at 9:15 in front of Judge Dugan.
All right, thank you.
Okay. All right, Carlos Long.
Your Honor, Mr. Long intends to either hire counsel or represent himself.
All right, thank you. All right, Mr. Long, it looks like you have 5 cases on the docket this afternoon. All right. Case number 2015 CF 14684. Case pending in front of Judge Dugan. Underlying charges: possession of a firearm by convicted felon and possession of cocaine. It's your 3rd FTA. In this case, Judge Dugan signed an arrest warrant, no bond. Your previous bond of $20,000 is being set aside and released at this time. Next court date for docket sounding is July 24th, 8:30 in front of Judge Dugan. Case number 2018 CF 34012. All right, this looks like a new case. Charges are possession of cocaine, 2 counts of use or possession of drug paraphernalia, giving a false name or identification to law enforcement, and operating a motor vehicle without a valid driver's license. All right. All right, Mr. Loughran.
2,000 is the count 1, 500 for count, each for counts 2, 3, 4, and 5.
Okay. All right, sir. Setting bond on count 1, 2,000, count 2, 500, count 3, 500, count 4, 500, count 5, 500. Not to possess or consume illegal substances or paraphernalia. Next court date for your arraignment, July 31st at 8 o'clock in front of Judge Silverman. Next case, 2018 CT 19808. You failed to appear for a plea in front of Judge Ingram. She signed an arrest warrant. Your bond is $1,000. Next court date, docket sounding August 21st, 9 o'clock in Melbourne.
I got one case that say no bond.
I'm sorry?
I got no bond on one of the charges.
Back on the first one, it was your third failure to appear for a felony case. It is no bond.
Yes, I can't get out here.
You can't, but I have to address each one of your cases, so you're going to need to stand right there until I finish, okay? We're almost done. Next case, 2018 CT 27439. You failed to appear for a traffic arraignment in front of Judge Ingram. Bond is $500. Next court date, docket sounding August 21st, 9 o'clock in Melbourne. And case number 2018 CT 25764. Again, you failed to appear for a traffic arraignment in front of Judge Ingram. Bond is set at $1,000. Next court date, docket sounding August 21st, 9 o'clock in Melbourne. All right, so now you're finished. Thank you. Mr. Montrose?
Yes, ma'am.
All right. All right, sir, I'm appointing the Public Defender's Office to represent you. You are charged with possession of a controlled substance without a prescription, driving while your license was suspended, revoked, or canceled with knowledge, and use or possession of drug paraphernalia. Okay. All right, I find probable cause for each of the charges. State.
2,000 is the count 1, 500 is the count 2, and 500 is the count 3.
All right, Mr. Kennedy.
No objection to the schedule, Judge.
All right, Mr. Montrose, bond for count 1, 2,000, count 2, 500, count 3, 500. No possession or consumption of illegal substances, no paraphernalia.
So 3,000, what, 2,500, 500?
Correct, so it's a
Okay.
total of 3,000. Your next court date is July 31st for your arraignment in Vieira. Okay.
Who's that in front of, which judge?
It's going to be in front of Judge Koenig for your arraignment, but your case judge is Judge McKibben,
All right, but July 31st?
July 31st. All right, do we have Jolene Newman? All right, Ms. Newman, I'm appointing the Public Defender's Office to represent you. You're charged with aggravated battery, domestic violence, and resisting arrest without violence. All right. All right, state's recommendation.
Your Honor, I've had some contact, the state has had contact with the alleged victim in this case, And where he goes through the different items that are in the 923, he also requests that the victim stay away from the property and have no contact with him.
Okay. All right. Do you have a recommendation on bond?
Yes, as to the aggravated battery, 15,000. As to resisting without violence, 500.
All right, Mr. Kennedy?
Judge, I'd ask the court to consider bond of no more than 5,000 for count one and 500 for count two.
All right.
No FTAs.
And schedules at 5,000? Is that right?
Yes.
Aggravated battery.
I would argue this, the schedule has it's a second degree felony.
So that would actually be the 15,000.
It's 15,000 is what the
Okay.
schedule.
All right. Okay.
Yes, I stand corrected.
All right.
I'd still ask for 5,000.
Yeah. All right, after having reviewed everything, I'm going to set bond at the scheduled amount, 15,000, and count to 500. You're not to have any contact with the alleged victim, direct or indirect, at this time, not to return to the residence except for a one-time return with law enforcement if you need personal belongings, and your next court date is July 31st at 8 o'clock in front of Judge Koenig for your arraignment. Okay.
Your Honor, this one was late. She didn't get the swearing.
Okay. Is this Ms. Shields?
Yes, ma'am.
All right. Okay. All right, ma'am. You weren't in here earlier, so let me just have you raise your right hand. Do you swear affirm that any testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, state your name.
Tracy Louise Shields.
All right, Ms. Shields, although I just swore you in, I would advise you not to make any statements regarding the facts and circumstances around your arrest. It could be an admission that could be used against you at some point in time, okay? All right, so I'm appointing the public defender. Actually, you did not have an
I
opportunity.
have a paid lawyer.
You have a lawyer?
Yes.
All right, who is that?
I'm Daniel Martinez.
Mr. Martinez? Okay, all right.
On my felony case.
Right, on a different case. All right, do you intend on hiring him for these cases at some point?
I'm not in the misdemeanors. Just the felony.
Okay. All right, yeah, you do have one felony and one misdemeanor case that we'll be dealing with today. But at this point, you don't want to apply for the appointment of an attorney, correct?
No.
Okay. All right. With respect to case number 2016 CF 27407, you're here on a contempt charge, failing to serve. I don't know if it's farm time or jail time.
Jail time.
It's jail time. To report and didn't. Okay, I remember reviewing this. Okay. All right, so based upon my understanding of your situation, you were to turn yourself in to begin a jail sentence. You failed to report, which is why the warrant was issued. Obviously, no bond. Your next court date to address the contempt charge is August 15th at 9 o'clock in front of Judge Reinman. And in case number 2017 MM 37407, let me just ask. So just if she doesn't post.
She doesn't post them on.
All right, so in the second case, you failed to appear for docket sounding in front of Judge Babb. She set bond at $1,000. And she put on the warrant to release after 25 days of jail with a new court date. It may be a moot issue because of the first case that you're being held on anyways, but I just want to let you know that that was what was on the arrest warrant. Your next court date for Judge Babb is July 30th for an order to show cause, okay? All right, thank you. All right, Leo Smathers. All right, Mr. Smathers, you have 4 cases on the docket this afternoon. I'm going to appoint the Public Defender's Office to each of your cases. I need to figure out, take a look at a few things to figure out what's going on with each of these cases, so give me just a moment. Because of the battery DV. All right. The FTAs. I assume it's probably because he was picked up. Yeah. Okay. I'm going to kind of start backwards here and jump around a bit. In case number 2018 CF 19000, this case pending in front of Judge Reinman, you had a mental health status hearing that you failed to appear for. So there is a no bond warrant that was issued by Judge Reinman. Your next court date is July 11th at 1:30 in front of Judge Reinman. And then jumping to 2016 CF 47918, it's number 36 on the docket. It's another failure to appear warrant from Judge Reinman for failing to appear for mental health status hearing. So it's the same thing, different case. No bond on that. Next court date also July 11th at 1:30. Then we have a new law violation, case number 2018 MM 34021. You're charged with battery domestic violence. All right. Okay, find probable cause for the charge. State's recommendation for bond.
$1,000, Your Honor.
No objection.
Okay. All right, so Mr. Smathers, your bond's being set at $1,000. You reside with the victim? You reside in the same home as the victim?
Yes.
Okay, all right. You're not going to be able to return to the residence or have contact with the victim for now, okay? You're being held on the other cases anyway, but if at some point in time you are able to post a bond on those cases, you need to make sure that you abide by the conditions of your release on this case, okay? You'll be authorized a one-time return with law enforcement to get personal belongings if you need it, but outside of that, you can't return to the house, okay? Next court date is July 17th at 1:30 in front of Judge Silverman for that case. Lastly, you have an on-site violation of probation, underlying charge of possession of less than 28 grams of cocaine and 2 counts of paraphernalia. You actually have 2 things going on in this case. It's a no bond, failure to appear bench warrant. Same thing, you didn't show up for a mental health status hearing in front of Judge Reinman, so you're going to be held on that until you can address it with her. And with respect to the on-site VOP, it's already a no bond for this case, but I guess just for the purpose of paperwork, Mr. Bachran, what's your position on bond?
Judge, I would simply ask it to stay where it is because he's in the mental health status.
So just keep it where it is?
He's been declared.
Okay, okay. All right, so I'm going to keep it at the no bond status. Next court date is July 11th at 1:30 in front of Judge Reinman. So that'll take care of all of your cases. All right, Mr. Sova?
Yes, ma'am.
All right, sir, I'm appointing the Public Defender's Office to represent you. You're charged with battery, domestic violence. All right, if I'm probable cause. State's recommendation.
$1,000, Your Honor.
Any objection?
No, ma'am.
All right. Okay, sir, I'm setting bond at $1,000. You're not to have contact with the alleged victim and not to return to her residence. I assume you did not. Actually, it was your residence. She does not reside there, correct?
Absolutely not.
Okay, all right. So, assuming that's the case, you can't go to her residence because you can't have any contact, but you can return to your residence as long as she's not there. Okay. All right. Next court date, July 17th, 1:30. Judge Silverman.
Thank you, ma'am.
All right. Thank you. All right, Mr. Strong. No.
Your Honor, Mr. Strong intends to either hire counsel or represent himself.
Okay, thank you. All right, Mr. Strong, you are charged with battery, domestic violence, and domestic battery by strangulation. I do find probable cause for each of the charges. Bond recommendation.
1,000 for count 1, 5,000 for count 2.
All right, I see a prior, and that's probably not a felony. Okay. All right. I'm going to set bond at on count 1 at $5,000, count 2 $5,000. Not to have any contact, direct or indirect, with the alleged victim in the case, not to return to the residence. My assumption is that you lived in the residence with the victim. All right, you'll be authorized a one-time return with law enforcement to gather personal belongings, but that's it. Okay. Next court date's going to be July 31st at 8 o'clock in front of Judge Silverman. Mr. Warren?
Jeffrey Warren.
Okay.
Your Honor, if Mr. Warren would qualify, it's conflict.
Conflict, okay, thank you. All right, so I'm going to go ahead and appoint conflict counsel for you. You're charged with grand theft of a motor vehicle and uttering a forged instrument. All right, I find probable cause for each of the charges. State's recommendation.
Yes, as to count 1, 2,000, this is count 2, 2,000.
Okay. All right, I don't see any prior FTAs, so I will set bond on count 1 at 2,000, count 2 at 2,000. You're not to return to the location of the offense. You're not to have any contact with the alleged victim with respect to count 1, the grand theft charge. Your next court date is July 31st at 8 o'clock in front of Judge Silverman for your arraignment. Okay.
Yes, ma'am.
Thank you. Okay. All right, Ms. White?
Yes, hello.
All right, ma'am. I'm appointing the Public Defender's Office to represent you in your case.
Judge, that'd be conflict.
It would be conflict, okay? So I'm going to appoint conflict counsel, okay? You're charged with battery and domestic violence. Okay. All right, I do find probable cause. Mr. Loughran?
$1,000, Your Honor.
All right. Okay. Ms. White, I'm going to post or set your bond at $1,000. You're not to have any contact with the alleged victim or return to the residence for
I have a
now.
question.
Judge,
Yes,
I believe the alleged victim is not allowed to return to the residence.
he's not allowed to return to,
Him?
Yeah, he's not allowed to be there, right?
okay.
So can I go back?
So he is not permitted to be at the residence, correct?
That's correct, Judge.
Okay, so you can, assuming that that's the case, you will be permitted to go back to your home, but you cannot have any direct or indirect contact with the victim until
That's fine.
further notice. If you want to have that modified at some point, you'll have to address it with Judge Silverman. Okay. All right, your next court date is July 17th at 1:30 in Vieira. All right, and what is your name, ma'am?
Jenna Whiteway.
Mark Segreto? Mark Segreto?
Do
Mark Segreto?
we have Segreto or we already did Skinner?
Judge, Mr. Segreto is not here right now. He is a public defender client. I would waive his appearance and make the court aware that the state did file as charged, so
They did file.
nothing really changes.
Okay. All right, so the state did file in Segreto. Bond remains at $5,000. There's no previous conditions